ABCI Infrastructures Private Limited versus Union of India, the Chief Justice of India, Justice Sanjiv Khanna, said that this was an avoidable litigation where no doubt there was a mistake on the part of the appellant. Instead of taking a pragmatic approach, the Border Roads Organization under the Ministry of Defense, Union of India, adopted obdurate and overly legalistic stance, causing a delay in the project's execution. Facts of the case were: on 23rd of February 2023, BRO invited bids for the design and construction of two-lane twin tunnels approximately 4.1 kilometers long at Shinkunla Pass, including civil, electrical, and mechanical work, with approaches connecting the Darcha-Padam highway to NSDL specifications in Himachal and Ladakh. The estimated cost of the project was rupees 1504.64 crores. The project was to be completed within 48 months and the bid security amount was 15.04 crores. The appellant was ranked as L1 bidder with the bid price of rupees 1569. According to the appellant, they had quoted bid price of 1569 crores. However, due to what they claim was a system error, the quoted amount appeared as just 1.1569.0. The appellant claims that they discovered the mistake on 24th August 2023 when the financial bids were opened and announced, and therefore on the next day, 25 August, they informed the authorities that their actual bid was 1.1569 crores, not 1569. They attributed the error to a typographical mistake or a critical technical issue with the server. While we would not accept the plea of system error, the figure quoted was clearly unrealistic, patent error, and mistake given the scale and nature of work tendered, though the mistake was bald faced, what followed is incomprehensible. With Border Road Organization insisting on accepting the bid in spite of letters from the appellant wanting to withdraw from the tender. BRO, guided by Evaluation Committee, instead of accepting the obvious, while letter dated 26 August 2023, called upon appellant to justify quoted amount of 1569 by providing a detailed price analysis, including scope of work and completion schedule, risk allocation, safety requirements, and proof of capability to complete the project. By 31 August 2023, on 30 August, the appellant reiterated that their intended bid was 1569 crores, not 1569, attributing the error to a technical or typographical mistake. On 7 September 2023, the appellant sent another letter stating that they should not be considered L1 bidder and the bank guarantee of 15,0464,000 may be returned to them without encashment. On 12th September 2023, appellant again wrote emphasizing that the bid was an error and the bid security should not be forfeited. While letter 16 September 2023, BRO unmoved wrote to appellant's bank, the State Bank of India, stating that the appellant had been declared a defaulter and their bid security was to be forfeited. The bank was asked to encash the bank guarantee and remit rupees 15,0464,000 to BRO. The appellant filed a writ petition before the High Court of Himachal Pradesh at Shimla, which stands dismissed by judgment dated 7/10/2023. The short question before Chief Justice said us is that whether BRO was justified in accepting the bid of 1.1569 and on failure of the appellant to execute the agreement asking for forfeiture-wide encashment of bank guarantee of rupees 15,0464,000. A mistake may be unilateral or mutual, but it is always unintentional. If it is intentional, it ceases to be a mistake. Mistakes or errors, though avoidable, are committed inadvertently. They have varied consequences in law. As per Section 20 of Indian Contract Act 1872, where both parties to an agreement are under a mistake as to matter of fact essential to an agreement, the agreement is void. The explanation to Section 20 states that an erroneous opinion as to value of thing which forms the subject matter of an agreement is not deemed to be a mistake as a matter of fact. The court must exercise a lot of restraint in exercising the power of judicial review in contractual commercial matters. The doctrine of proportionality nevertheless applies when the error or mistake is writ large and equity matters the grant of some relief. Reference was made to the decision in Coimbatore District Central Cooperative Bank versus Coimbatore District Central Cooperative Bank Employees Association and another, with discussing the question of proportionality or punishment imposed on the striking workmen. It is observed proportionality is a principle where the court is concerned with the process, method, or manner in which the decision maker has ordered his priorities, reached a conclusion, or arrived at a decision. The very essence of decision making consists in the attribution of relative importance to the factors and considerations in the case. The doctrine of proportionality thus steps and focuses true nature of exercise, the elaboration of a rule of a permissible priorities. D. Smith states that proportionality involves balancing test and necessity test, whereas the former permits scrutiny of excessive onerous penalties or infringement of rights or interests and a manifest imbalance of relevant considerations. The latter requires infringement of human rights to the least restrictive alternative. In Halsbury's Laws of England, the court will quash, it is stated, exercise of discretionary powers in which there is no reasonable relationship between the objective which is sought to be achieved and the means used to that end, or where punishment imposed by administrative bodies or inferior courts are wholly out of proportion to relevant misconduct. The principle of proportionality is well established in European law and will be applied by English courts, where European law is enforceable in the domestic courts. The principle of proportionality is still at a stage of development in English law. Lack of proportionality is not usually treated as a separate ground for review in English law, but it is regarded as one indication of manifest unreasonableness. The present case does not fall under any exception, for the error or mistake in quoting a price of rupees 1569 does not require any argument and cannot be debated as it is self evident. A contract of this nature for an estimated value of more than 1500 crores spreads over 48 months, requiring construction of roads and tunnels of the length more than 4 kilometers in a hilly terrain, can never be executed for a mere 1569 rupees. We agree with the BRO that the appellant was at fault and had made the mistake of having failed to add the required zeros in the financial bill. The plea of the system glitch should not be accepted as others had successfully uploaded their bids without problem. BRO justified in cashing the bank guarantee by citing delays caused by issuing a second notice inviting bids. The claims is baseless as BRO was aware of rupees 1569 error. Instead of declaring the bid non-est due to the clear mistake, BRO asked the appellant to justify the bid, cancel the notice, declared the appellant a defaulter, invoked the bank guarantee, and issued fresh notice inviting bids. Thus, BRO's claim that the delay was entirely due to appellant's mistake is flawed. Ignoring BRO's own lapses, mistakes, including by the authorities, should be resolved through corrective steps. A practical approach could have avoided the delay, which was caused by BRO's refusal to acknowledge the appellant's genuine error and unwarranted cancellation of the bid. The appellant was directed to pay rupees 1 crore to BRO as a consequence of their error. Upon receiving this payment, BRO shall return the appellant's original bank guarantee or demand draft of rupees 15.04 crores within 1 week.